Hey, welcome Employment Law Show once again. John Scholes and Lior Samfiru. We are back at it. Good to have you along, joining us for the next half hour or so. And I'll give you some contact information right off the top before we get into the meat of the show for today. 1-855-821-5900. help@employmentlawyer.ca is the email address we're going to use during the show. And anytime as well, if even before you call Lior, member his team, you can go to pocketemploymentlawyer.ca. There's a ton of information there, including a section on wrongful dismissal. There's a section on disability law. It's a really robust website. If you haven't been there before, pocketemploymentlawyer.ca. But today on the show, Lior, as you know, termination without cause, what you need to know. We will tackle that in just a bit. My brother, what's going on with you?
Well, here we are, doing this show again, informing people about their rights. We're being very careful, socially distancing, as hopefully everyone else at home is as well. But John, since we last spoke, since we last did the show, so many issues have come up with respect to employment law, workplace rights, people losing their job, being laid off temporarily, not allowed to work from home or forced to work from home. So I deal with these issues every day, and I encourage you. We're going to talk a lot about employment law right now on the show, but if we do not touch on your issue, on your specific situation, let's connect off air. We'll give you that contact information throughout the show so that we can have a private discussion about your workplace issue. Remember, we all may be in quarantine, but the one thing that's not in quarantine is our employment laws. Employment laws are still here. They still protect you. They're still quite robust. So if you're facing any problem, any issue, there is likely a solution. So let's have that chat. Let's discuss your legal rights if you're facing a workplace problem. But to get started on the show today, the Employment Law Show, let's talk about a situation that came across my desk very recently. Now, John, I've been saying on the show for months that if you've been laid off temporarily, one of the options that you have is to treat that as a termination and get your severance and move on. And I've said that one of the reasons you want to consider doing that is that if you don't do that, you may now give the company the right to do it again. Well, a lot of people now are learning that, unfortunately, the hard way. I got a call from a lady this week. She had been laid off early during the pandemic, and she wanted to keep her job. I understood that, of course, and was home for about 3 months or so, and then was called back to work. She went back to work, continued working. Well, 3 months after that, second wave of COVID, now she's been put on a temporary layoff again. Her employer says, we have no idea when we'll be able to call you back. It's going to be months and months for sure. And that's when she called me and she said, well, I don't want to, and I really can't afford to be off again. What are my rights? So here's the interesting thing about this situation. When she was laid off that first time, that first layoff essentially was illegal. She could have treated it as a termination of her employment, and she could have gotten severance. For her, that would have been over a year's pay. Well, she accepted it. Unfortunately, by accepting it, she gave the company the right to do it again. So now when she's been laid off a second time, her employer now is in a situation where they can do that legally. And she may not be able to do anything about it only because she accepted it that first time. So she now has to essentially wait and see what her employer will have to do. Depending on what province you're in, your employer would have a certain period of time to make that decision. But that's only if you accept the layoff. And if you accept one layoff, you may be accepting future layoffs. So if you're now in that situation, if you're in a first layoff, company laid you off, they haven't called you back to work, you've been sitting on the fence wondering what to do, well, one of the options, as I said, is to treat this as a termination. Get your severance. Severance, by the way, could be as much as 2 years' pay. But if you don't do that, if you accept it, if you stay home and eventually go back to work, by doing that, you've given the company the right to do it again and again. And John, that could be a huge problem.
Yeah, I mean, what you're talking about is literally speaking to tens and thousands of people across the country. And in some jurisdictions as well, I know you've mentioned this on the radio show, and I'll give you details how you can catch our radio show in just a minute. But they've also extended the amount of time that you can be off until like the end of 2021 in some jurisdictions, right? It's really bad.
Well, in Ontario, just as an example, you could actually be off until the spring of 2022. So that's if you accept the layoff. Now, different provinces, Alberta, BC, different situations. But either way, you don't want to be in a situation where now your employment is such that you work for a few months, you get laid off for a few months, again and again and again. most of us, we couldn't work that way. We couldn't pay our bills that way. So severance may become an attractive option if you've been put on a temporary layoff.
Employmentlawyer.ca, I was just about to mention that. That is the website you want to go to if you want to catch links to a radio show across the country near you. And tune in to that every week. It's an hour-long broadcast, and we like to get the phone calls from those shows. We play them back on this TV show, and Lior talks about them. The first call for today is coming up right now, guys.
I got termination of employment letter, termination without cause. They're giving me notice instead of paying me out. Now, on the termination letter, it says they will pay vacation pay, but the amount is not stated. If I sign that I accept these terms, it says I can't go after them if there's a dispute.
How long had you worked for this company?
15 years. I'm in the IT field.
How old are you?
52.
So this is an interesting, a common situation where he's asking questions about vacation pay. Fair enough. But I suspect there's probably a bigger issue lurking here than vacation pay, which is the amount of severance that he's owed. On the vacation pay, it's actually straightforward, right? He gets whatever vacation has been accrued to the date of termination. But I find, John, in many of these situations where people are calling me up, well, I think there's vacation pay owing or overtime owing, or I want to know how long the company has to file my record of employment, there's really a bigger issue, which is how much severance you're actually owed. So let's address this issue with respect to this question that we received. Let's find out how much severance this person is owed, because that's probably a much bigger issue than the vacation pay. Rather than me just tell you how much severance he's owed, let's take his information and plug it into pocketemploymentlawyer.ca. We have a severance calculator tool there. You can all use it. It's free and anonymous. And let's find out how much he's owed. So he's in an IT role. He's been there for 15 years. You can see that on the screen, 52 years of age. Now, we don't know how much he's been offered, but what we do know is that he's owed, you can see that right at the bottom, 16 months of severance. Now, if his income, for example, is $65,000 a year, that's about $86,000 worth of severance that he is owed, 16 months pay. So money, I'll bet any money on the fact that this company may have offered him a lot less, only because that's what happens in most situations. Employers offer employees a lot less severance than what they're owed. So chances are, if you lost your job, yeah, there may be vacation pay or other things owed to you, but the real issue, the big issue, is how much severance you're owed. Chances are you're owed more than you realize, which is why you call me or you go to pocketemploymentlawyer.ca.
Yeah, not the only way to reach out. The phone call, the email as well. There's also a website, Lior, as you know, terminationquestions.com, terminationquestions.com. Go there. You can ask your questions, and either Lior or a member of his team will answer them and give you a good answer you can go forward with. First one for today, pal, is Dahlia, and she might not have caught the beginning of the show. Dahlia says, can my employer put me on another temporary layoff because of the ongoing impact of COVID-19?
Well, the key here is the word another. So I take that to mean that she has already been put on a layoff, probably came back to work, and now she's asking, can her employer put her on a second temporary layoff? And the answer to that, unfortunately, is potentially yes. Yeah. And only because of the fact that this was presumably the second layoff. If she were to write and say, I've just been put on a layoff, or I've been on this layoff for a while now, is this legal? The answer to that is easy. No, it's not legal. Doesn't matter what province you're in. You're in Alberta, you're in Ontario, you're in BC, somewhere else. It's not something your employer is allowed to do. But if they do it the first time, if this is now another layoff, as she said, unfortunately now a new term has been created, a new term that says we have a right to do it. How do we know we have a right? Because we did it before. You said it was okay. You accepted it. That means now we can do it again. And by the way, John, this doesn't just apply to temporary layoffs. This applies to any other change that an employer imposes, a change in pay, a change in hours, change in schedule. If it's a big change like that and you accept it, by accepting it, by being a team player, which is a good thing, of course, but by accepting it, you may now have given the company the right to do it again. So you want to be very, very careful whenever you're accepting or agreeing to a significant change in terms of employment.
You know, if it's from the outset somebody's first shot of getting put on a temporary layoff by their employer, even if it's now, can they go to that employer and say, look, I understand times are tough, it's COVID-19, this is going across the country, but I don't want this to become a regular thing. I'll give you a break this time around, if the understanding that I'm not going to allow you to do this again. Can they do something like that or put it in writing to that effect?
It is a good idea to do that, to essentially say to your employer, just so we're clear, I'm going to accept this one and only time because
Right.
of this unique situation. But for that to have even more weight, you would want the employer essentially to agree. Say, yeah, we're with you. We have an agreement on that front. So is it better to say to your employer, I'm just doing this one time? Yes, that may not get you all the way. It would be a lot better. It'd be a lot more powerful if the company agrees and now that's the deal. We have the right to lay you off once, no more. But it's certainly better to do that, to send that message rather than just be silent and go back to work.
All right, we got to take a short break, Lior. We'll get to that when we come back from the break. It's termination without cause, what you need to know. We will cover that off. In the meantime, 1-855-821-5900 is the phone number and email address. You want to send one along, help@employmentlawyer.ca. It's the Employment Law Show, and we'll be right back. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back. Employment Law Show. John Scholes, Lior Samfiru with you again this week. Reaching out anytime. 1-855-821-5900. You can call after the show for a lengthy conversation with Lior or one of his colleagues. But I want to get to this, Lior, and that is termination without cause. And I want to get through some of these points. This is basically focusing, of course, on non-unionized employees. So I just want to put that out there from the outset. What does it mean to be terminated without cause by your employer?
So a termination without cause is actually the most common form of termination. If you lost your job, chances are it's a termination without cause. And that's kind of a catch-all term that refers to a termination that's not because of something awful that you did. So a termination without cause is a termination because of a restructuring or cost-cutting or the company shutting down its operation or having to make a difficult business decision to let you go. All these situations where you didn't commit a terrible mortal sin, but you had to lose your job, is still a termination, of course, and we call that a termination without cause. Now, that doesn't mean that the employer did anything wrong. An employer generally is allowed to terminate employment without cause pretty much for any reason, as long as it's not discrimination. But of course, they have to pay severance, which we'll talk about in a second. But oftentimes people hear this term, termination without cause, or they're being told when they're let go, we're letting you go without cause. And it sounds bad. Well, if there's no cause, how dare you let me go? Well, that's just a legal term. It is something an employer is allowed to do. They can let you go without cause. Some employers call it restructuring, what have you. But of course, the real issue here, which we'll get to in a second, is the amount of severance you're owed if you've been let go without cause.
You know, I know once you've explained that to potential clients or people who call the office, the follow-up question quite often is, yeah, but can I still get EI, employment insurance, when I'm terminated without cause?
Yeah, because people think, well, if they let me go supposedly without a reason, does that somehow affect my EI or right now other benefits that the government provides? So the answer, the good news is absolutely yes. In fact, it is a termination without cause that qualifies you for EI. The flip side is if you were terminated for cause, that means you did something terrible, something awful. That may actually disqualify you from EI if it's true. But a termination without cause absolutely qualifies you for EI or other government benefits if it's COVID-19 related. So yes, do not worry about EI. You will absolutely get EI. You will get a record of employment from your employer, which will often put or say a termination without cause. That's exactly what you wanted to say. That allows you to get EI without any problems. EI is not going to dispute that, question it. It's legal. So yes, a termination without cause equals getting EI. Absolutely.
By the way, a lot of this information that we're going over here on the show today, pocketemploymentlawyer.ca, great resource to check it out on your own at your leisure, free and absolutely anonymous. If you want to just close the browser when you're done, you can walk away. If not, there's a contact button at pocketemploymentlawyer.ca as well. Another logical question, I mean, you led right into it. Do you still get severance from your employer if you're let go without cause, like the old 2 weeks per year, whatever most people might think it is, right?
Well, that's where the money is, quite literally.
Yeah.
So an employer is allowed, as I said, to let you go for cause, but so without cause, I should say. They're allowed to let you go, but it's a question of severance. And most people that are let go without cause are actually wrongfully dismissed, and they're wrongfully dismissed because their employer does not pay them or offer them proper severance. So let's be very, very clear. It's not a week per year of service. It's not 2 weeks per year of service, or frankly, any other formula. There's a number of factors that go into determining how much severance you're owed. The main factors are your age, your position, and the length of your employment. There's some other factors, including the fact that right now we're dealing with a pandemic. The fact that we're dealing with a pandemic means it's going to be more difficult, potentially, to find another job. That means more severance. It's going to take you longer to find another job, therefore more severance. Now, for many people, that could be a month per year of service, or even 2 months per year of service. Severance usually maxes out at 24 months. And I want people to remember that just because you're a short service employee does not mean you get little severance or no severance. In fact, a person that's worked for a few months only for a few months, could be owed a few months severance. You may have worked for 6 months, and you could be owed 4 months severance. You could even be owed 6 months severance. So that's why it's so important to give us a call to get legal advice if you lost your job. I don't care if you worked for a month. I don't care if you worked for 50 years, if you're in a senior position or a junior position. With respect to severance, the law is actually quite generous. And the vast majority of people that are otherwise let go legally, without cause termination, that's a legal termination. They're still now being treated illegally by being offered inadequate severance, 90% of the time, very common. So if you lost your job, you had a bad Friday, you went in, they let you go, you're looking at those papers. I don't have any magic powers, but I can tell you, even without reading that severance letter, that it's extremely likely that whatever you've been offered is a lot less than what you're owed. Don't believe me? Go to pocketemploymentlawyer.ca, find out for yourself.
You said, a bad Friday and, the termination papers. That led me quite nicely into the next question. That is, people wonder about that. How about these papers I'm supposed to sign? How about this deadline that's at the bottom of my offer? I'm starting to panic. I understand I get severance, but what about this issue?
Yeah, so we talked about having those papers in hand. One of the things that those papers are going to say is, well, you have to accept our offer by a certain date, by a deadline, Friday, Tuesday, whatever that deadline is. And this is going to cause a lot of stress. Wait a second, they offered me a certain amount of severance, but look, it says right there that if I don't sign it, I don't get it. So this is where I come in and I say, do not worry about that deadline. Your legal rights are not going to expire on that deadline. In fact, your legal rights are not going to expire for 2 whole years. That deadline, frankly, is a pressure tactic. A company often may count on the fact that an employee is going to feel pressured to sign this offer because of the deadline, and they will sign it, accepting inadequate severance. So think about this situation. Company owes employee 18 months severance. They offer the employee 6 months, but the employee has to sign this by Friday. Well, that's absurd, because the employer owes 18 months pay. So why would the employee accept 6 months by Friday? That employee should say, thanks, but no thanks. I'm going to get legal advice, and then I'm going to get my full 18 months. That's what you have to do. So that deadline is meaningless. You have my blessing, my permission, and my encouragement to ignore it. Do the right thing. Get advice instead.
And then the next question you get, Lior, is this one. Well, I understand that, but why do I need to go to you? Can't I just go to the Labour Board in Ontario or the Legal Standards Branch in BC, whatever they call it out there? I mean, can't I just do that? Why do I need you? I'll just go to the government.
Yeah. Why don't I just go to the government? There's a department dealing with these things. Well, that department, Ministry of Labor, Employment Standards Branch, Employment Standards, whatever you want to call it, is very well equipped to deal with certain employment issues, overtime, vacation pay, holiday pay, a few other issues as well. They cannot help you with losing your job. They cannot help you get your full termination entitlements. So remember, the government can only help an employee get their minimum termination entitlements. In other words, a very small portion of what they're actually owed. So that's why if you're owed 18 months severance, your minimum entitlements could be 8 weeks. Well, why do we care about that 8 weeks if you're owed 18 months? So no, you cannot go to the government. You cannot go to the Ministry of Labor. You cannot go to the department of any kind in your province if you lost your job. For that, you have to speak with a lawyer. You don't like me? That's okay. Speak with another lawyer. But that's what you absolutely have to do, no exceptions. In fact, by filing a claim with the government, you could be foregoing and giving up on your full rights. Please don't let that happen. Don't believe me? Again, go to pocketemploymentlawyer.ca, a resource that allows you to calculate in seconds the full amount of severance that you're owed. Free, anonymous. You can grab your smartphone right now and just go to pocketemploymentlawyer.ca.
Does the or unemployment contract existing, or you dust it off, does that have any effect on your severance, your termination?
So employers over the years have gotten kind of wise to this issue of severance, and they realize, holy cow, severance could be a lot. We could owe someone as much as 2 years' pay. So how do we deal with that? How do we reduce these obligations? Well, one way employers try to do that is by having an employee sign an employment agreement when they start working that limits their future severance. Now, fortunately, in many cases, those terms, those termination terms, are actually unenforceable. So even though a company tries to limit entitlements, they have not been able to do so successfully. Probably 3/4, maybe even 80+% of these termination terms are not enforceable. So yes, we need to look at an employment agreement if you sign one, that's if it speaks to the issue of termination, but just because it does, just because it tries to limit your entitlements, does not mean it does that properly. So don't lose sleep over that. If you lost your job, contract or no contract, call me and let's discuss.
All right, you want to reach out to Lior about any of those talking points, but now before we get to a break, I want to get to one more phone call before that time from our radio show, Lior. So phone call number 2, it's coming at you right now.
I was dismissed from my job in regards to an addiction that I have. Got my final notice, my third notice, in regards to any more time lost, that I would be dismissed. I confronted the company the following day and said, yes, I do have an alcohol issue. And my doctor was aware of my alcoholism as well. I was just wondering what rights I have. They did give me a severance with my vacation, but apparently the check's still in the mail.
What kind of job? What do you do there?
Truck mechanic, 10 years.
Approximately how old are you?
48.
Bad move.
Okay. So let's be very clear here. So he says he has a drinking problem, that he suffers from alcoholism. So alcoholism is a disability. The law recognizes that. Human rights laws across the country recognize that if you're an alcoholic, if you have that type of a disease, it is that. It's a disability. It's a disease. That means that if your work gets impacted by this disability, it's ultimately not actually your fault because you're dealing with this disease. So that means that an employer not only cannot fire you because you have a disability, your employer has to accommodate you. That may mean giving you time off. That may mean pointing you to the right direction in terms of getting help, but you cannot be disciplined and you cannot be let go if you have an alcohol drinking problem. Now, if you were irresponsible, you're not an alcoholic, you just drank too much and came into work, yes, that's not a disease, that's not a disability. You can absolutely be disciplined for that. But if this person is an alcoholic and told his employer that he's an alcoholic, that employer is not allowed to let him go. That's a human rights violation. So not only is he owed severance, he could easily be owed a year's severance. He's been there 10 years, he's 48 years old. He could potentially be owed human rights damages as well. So a disability like alcoholism has to be accommodated. You cannot be terminated for that. That applies to other disabilities you may have. Remember that an employer that tries to contravene these rules and laws is going to have to pay a significant price.
All right, Lior, want to refer to our radio show again for another phone call, but got to take a break first, so we'll do that quickly and get right back into it. In the meantime, phone number to get a hold of Lior and his team, 1-855-821-5900, or send an email along, help@employmentlawyer.ca. It's the Employment Law Show. Coming right back. Stick around. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. Yeah, that website, employmentlawyer.ca, that is also where you go to find one of our radio shows across the country. You can tune into those every week, an hour-long radio extravaganza with yours truly and Lior. We always do good things on the show, and a bunch of phone calls every week. People have so many questions, Lior, so I want to get right to it. Our third phone call for the day is coming up now.
Calling on behalf of my sister, actually. She's an employee for 31 years. Her paperwork said that her company had entered into an agreement to acquire the assets of the company. A letter sent home saying that, unfortunately, there would be some layoffs. She was given a form letter, "Dear employee, your services are no longer required," but they offered her no severance after 30 years.
Well, that's absurd. I mean, this situation is exactly what we were talking about before the break. It's a termination without cause. If because of the purchase of the business, you're out of a job, well, that's a without cause termination. Nothing wrong with that legally, but of course she's owed severance, not even a question. I mean, she's been there for 31 years. The idea that an employer can think that they can let someone go without severance, frankly, even if it was 3 months, it would be absurd. But after 31 years, it's just ludicrous. So yes, she's been wrongfully dismissed. So let's go back to our good pal here, pocketemploymentlawyer.ca. Let's input her information there so that we can see, so that everyone at home can see how much she's owed, so that you can do it yourself if you lost your job. So she's in a clerical role, been there for 31 years. She hasn't been offered any severance, which is absurd. We see at the bottom there that not only is she owed severance, she's owed anywhere from 18 to 24 months of severance, from 1.5 years to 2 years of pay. That's how much she's owed. That's how easy, by the way, it is to use pocketemploymentlawyer.ca. So if you lost your job, sale of a business, restructuring, company shutting down its doors, cost cutting, you name it, you're owed severance, and it could be as much as 2 years' pay.
That's crazy. From, not even a Jelly of the Month club to 2 years' pay. It's absurd, as you said, right? But let's, you talked about the sale of the business. I know we only got a couple minutes left here, so I want to get to this one. Does that affect things differently than a company shutting its doors in bankruptcy or Chapter 11, whatever they call it, right?
So bankruptcy is where severance goes to die. Let's put it that way. If a company is actually bankrupt or in bankruptcy protection, unfortunately, employees will not get severance. We've seen many cases like that over the past few years in Canada, Sears being one example, for example. So no, but that's very different than a company shutting down its doors. A company deciding when to stop operating does not mean they're bankrupt, not even close. They may have assets, they may have money coming in. No, bankruptcy is a formal, specific legal proceeding. So if your employer shut its doors, that does not relieve them from the obligation to pay you your full severance. Bankruptcy, though, of course, is different, John.
Awesome. Good for another day. We'll pick it up again with lots more topics next time. Thank you for tuning in. You want to reach out now, 1-855-821-5900, the number. Emails help@employmentlawyer.ca. And a reminder, always, pardon me, even before you call Lior, pocketemploymentlawyer.ca. It's like having an employment lawyer with you at all times. So use that free and absolutely anonymous. We'll catch you next time, the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.